Welcome to Bright Ideas, Part 11, the continuation of our discussion of dispute resolution. When a dispute arises from a difference of opinion and informal negotiations with the school have failed, along with those of a facilitated IEP, a call for mediation is in order. Mediation begins the formal process of dispute resolution. Its outcome is legally binding and upheld by the courts. As noted in the overview in Part 10, mediation is a voluntary step on the part of both the school and the parents. Either party may refuse to participate for any reason. Mediation may not be used by a school system to either deny or delay a parent's right to a due process hearing. However, it is the least costly of all of the formal steps toward resolving a dispute, so there's no reason why mediation shouldn't be attempted before pulling out the big guns. Mediation is begun by contacting the Nebraska Office of Dispute Resolution, an arm of the Nebraska Department of Justice. A qualified, impartial mediator who is trained in effective mediation techniques will be brought in to assist in negotiating a settlement. There are independent mediation centers throughout Nebraska, and the State Department of Education maintains a list of qualified mediators who are knowledgeable in special education laws from which to draw. The cost of mediation is borne by the Nebraska Department of Education, so there's no cost to the school nor to the parents for this solution. The mediation session, or perhaps multiple sessions, will be held in a timely manner and at a location convenient to both parties. If successful, the result of the session or sessions will be a written agreement which is legally binding on both parties and is enforceable in any state or district court in the U.S. If unsuccessful, the parties may proceed to other remedies. Importantly, all discussions that occur during the mediation process remain confidential, and none of it may be used as evidence in any subsequent due process hearing or civil suit. If a dispute with the school system arises not merely over a difference of opinion, but over a specific accusation that the school has violated the regulations set out in Nebraska's Rule 51, there is one intermediary procedural safeguard not required by federal law, but available in Nebraska prior to filing a request for a due process hearing. In this case, the parents may file a state complaint alleging that the school district has not followed special education law. The alleged violation must have occurred not more than 1 year prior to the date the complaint is filed. The complaint is to be filed in writing using the state complaint form that is available on the Nebraska Department of Education's website or from PTI Nebraska. It must be signed by the persons making the complaint, and it must include facts about the alleged violation of the requirements found in Rule 51. It must also include a proposed resolution to the problem to the best knowledge of the complainant. The form is then sent both to the Special Populations Compliance Officer at the address on the form and at the same time to the school district itself. Filing a state complaint costs the parent nothing, but does take time, up to 3 months, and requires thorough documentation of the alleged violation. Unlike the state complaint, which alleges a violation of law has occurred, parents may file a request for a due process hearing when differences of opinion arise with the school regarding evaluations, IEPs, placement decisions such as the amount, type, intensity, frequency, or location of services, or other provisions of a free, appropriate public education. The school district may likewise request a due process hearing if the parents refuse to consent to an initial evaluation, or the district feels it shouldn't have to pay for an independent educational evaluation, or I.D.E.A.s. Both parties will need to be prepared with documentation in support of their position, and the assistance of attorneys or other experts would be helpful in this regard. Parents may consult their own lawyer, or alternatively, Nebraska Advocacy Services may be turned to for legal advice and guidance at low cost. A request for a due process hearing must be made within 2 years of the action that brought forth the complaint, unless the parent was prevented from filing a complaint due to specific misrepresentations or withholding of information by the school district. The request must be made in writing as a notice to the other party along with the State Department of Education. The request must outline the action that forms the basis of the complaint and include the name and address of the child or contact information in the event the child is homeless, the name of the school the child attends, a description of the problem along with the facts of the case, and the desired solution. No hearing may take place without the filing of such a notice. Models of a due process hearing notice are available on the Nebraska Department of Education's website. When a hearing is initiated, the school will remind the parents about the availability of mediation as a simpler solution if that hasn't already been tried. And within 15 days of filing a request for a due process hearing, but prior to the initiation of the hearing itself, the school must convene yet another meeting with the parents and relevant members of the IEP team called a resolution session, intended to once again focus the team and attempt to resolve the dispute before it escalates to the formal hearing. The purpose of the resolution session is to provide the opportunity to discuss the due process complaint, present the facts that form the basis of the complaint, and once more to allow the parties an opportunity to resolve the dispute before stepping up to the legal due process hearing. To set the tone, the school district is prevented from bringing its attorney to the resolution session, unless the parent is accompanied by an attorney as well. The resolution session can be waived if both parties agree in writing to waive it, or if they agree to return to the mediation process for settlement. One distinction, and an important one, between the resolution session and the mediation process is that there is no guarantee of confidentiality of information discussed in the resolution session as there is in the mediation sessions. If a settlement is reached during the resolution session, the parties will execute a legally binding agreement, just as in a mediation session. If the complaint is not resolved within 30 days of its receipt, the matter will proceed to the due process hearing. The due process hearing is not a court proceeding, however it does have a great deal in common with court proceedings. Either party may be accompanied, advised, and represented by an attorney and accompanied by other specialists in special education or disability issues. Each party may present evidence and confront, cross-examine, and compel the attendance of witnesses. At least 5 business days prior to the hearing, each party must disclose to the other the results of all evaluations completed and recommendations based upon those evaluations that the party intends to use at the hearing. Any evidence introduced at the hearing which was not previously disclosed to the other party may be barred from use. The hearing is held before an impartial hearing officer who must not be an employee of the state or local education agencies involved in the education or care of the child, nor have a personal or professional interest that conflicts with his or her objectivity in the hearing. The hearing officer must have knowledge of and the ability to understand the provisions of the federal and state regulations regarding special education, along with existing legal interpretations of federal and state regulations by the courts. And the hearing officer must possess the knowledge and ability to conduct hearings and render and write decisions in accordance with appropriate standard legal practice. The subject matter of the hearing is restricted to only the issues raised in the notice filed in the request for a due process hearing. No other issues will be allowed to be raised unless the other party agrees. We've noted all along the importance of FAPE, the Free Appropriate Public Education concept. Here's why. The hearing decision will be based on a determination of whether the child received a free, appropriate public education. It will be held that FAPE was not provided in the event that procedural inadequacies either impeded the child's right to FAPE, substantially impeded the parent's participation in FAPE decisions for their child, or deprive the child of educational benefits. The decision of the due process hearing officer is final. However, the losing party does have the right to pursue the matter outside of the educational system and into a court of law, either a state court or a federal district court, as a civil action. Each party is entitled to a verbatim record of the proceedings, either in written or electronic form. The cost of a court reporter to produce this record is borne by the state education agency. All other expenses of the hearing, though, are borne by the parties incurring them. Oh yes, and lastly, lest we lose sight of the fact that all this talk about dispute resolution is really about the education of a child with a disability, be aware that reaching the point of a due process hearing from the initial filing of a complaint can take a very long time. On average, a due process proceeding will reach its conclusion in 3 years. And while all of these escalating proceedings are pending, the child remains in the current educational placement until a resolution is reached. So you can see why due process is the nuclear option, the absolute last resort. Rarely will it be the best solution for the child. By contrast, a facilitated IEP can be concluded in a matter of several days. Mediation, a few weeks. Filing a state complaint, a few months. We've reached the end of Part 11 and the conclusion of 2 parts on dispute resolution. In Part 12, we'll discuss how extreme cases of behavioral disruption are handled.